Commission is now in session with the Honorable Chief Judge William C. McIntosh presiding. While court is in session, there's no talking, sleeping, or chewing of gum. Thank you. You may be seated. Good morning, Your Honor.
Morning, Judge.
Morning.
Good morning, Your Honor.
Are we ready to go, Madam Clerk?
Yes, sir. Yes, sir. We got the report reporter just came in at the same time as you.
Okay.
Calling,
Madam Reporter, are you ready?
Yes, Judge.
Okay.
okay. Calling Michael McIntosh. Oh, I'm sorry, Madam Clerk report. Did you need anything? Did you need anything like the docket? I usually send it to Maia.
I have the docket. Thank you so much. There are only 4 cases, correct? Thank you.
Yeah.
Calling case 230-602-1101. People of the state of Michigan versus Michael DeJohn McIntosh. Defendants charged with count 1, unlawful imprisonment. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Defendant is labeled as a habitual offender for defense notice, mandatory 25-year sentence. Today is the day and time for the bond redetermination hearing.
Judge, always a privilege, and good morning to Steve Vincent for the people, P71917.
Judge, good morning. May it please this honorable court. Philip Reagan, P57156 on behalf of Mr. McIntosh.
Mr. McIntosh, state your name for the record.
Your Honor, I'd like to represent myself in this bond hearing. My name is Michael McIntosh.
Okay. Well, sir, you have a right to have counsel. We have counsel here present for you, and you are rejecting having the House counsel, and you would like to represent yourself.
That's correct, Your Honor.
Okay. All right. We will have Mr. Reagan here just in case you change your mind. But your bond is currently $50,000. You may begin your defense.
Okay, Your Honor. Thank you for this opportunity.
And sir, just to make sure we're clear, we're not arguing facts today. We're just arguing bond. So continue. Bond.
Yes, sir, Your Honor.
Okay.
Okay. As far as bond goes, Your Honor, I've been at the time of arrest, 10/26. I'm working full time, 2 jobs, working approximately 60 hours per week. And I've been working. This alleged incident occurred on 8/20. Now I was picked up, arrested on 10/26. So that was like more than 60 days later since this alleged incidents happened. I was working 2 jobs, about 60 hours a week, 6 days per week, successfully working Monday through Saturday for about a year. I was released from prison 10/18/22. I told the parole board I would have a job within 3 weeks. I've been working and I got a job within 3 days. And I've been working at that job, the same job from 3 days out of prison until the current time of arrest. And so I personally, I would request a personal bond, Your Honor. And this person, the alleged victim was nothing more than a girlfriend that I providing works. I felt sorry for her, and I provided works, rides to work for her approximately 5-6 months. So I would respectfully ask that you consider a personal bond, Your Honor. Thank you very much.
Thank you. Mr. Prosecutor.
Judge, very, very, very serious allegations here regarding this individual. He's on parole for both an AWIM as well as weapons, felony firearms. You can see not only that, he has prior multiple convictions that he ended up getting paroled for. So bad to the point now where it's a half-core mandatory 25 years. as much as I do respect the fact that the defendant has been working, it doesn't take away from the significance of this particular incident, which Judge, quite honestly, is scary. To the point where we have an individual allegedly covering another individual with some type of clothing after taking off, Judge, apparently shoes and other parts of clothing, and then Judge, we have allegedly holding her for all intent and purposes like a hostage, imprisoning her unlawfully, wanting to get away, she can't get away, and then let's talk about the injuries, which there were, because allegedly there was punching and strangling. Your Honor, highly assaultive. If this was my case, I would have been asking for more. In terms of it, I think it's a $50,000 cash bond, tether, house arrest, based on the nature of the offenses, based on the allegations here, again, Judge, which supremely would scare anybody, let alone this complainant, which she said she was in fear. Respectfully, we're going to be asking for that cash bond to continue.
Sir, what are your
Your
work?
Honor,
Sorry, hold on, Mr. McIntosh. What are your work hours?
my work hours are approximately 7:30 a.m. to approximately 1:30 p.m. And I would leave that job and go straight to another job approximately 2 p.m. until about 7 p.m.
Okay. All
And
right.
I really like to debut his statement, Your Honor. Your Honor, this alleged incident, this incident that the prosecutor mentioned was over 20 years ago when I was arrested. About 20 years, occurred about 20 years ago in 2004. I have gone all these years without a crime, without committing a crime, Your Honor. That incident what I was arrested for was occurred in 2004. Okay. I went 16 years in prison without committing crimes, without getting major violations, and also too, Your Honor, the prosecutor states that the harm to the alleged victim, Your Honor, police were called to the alleged victim's house, and the alleged victim refused EMS. Didn't need any medical attention. So I object to that, Your Honor. So I humbly ask that you give me a personal bond, because this is someone that I dated, and it was just more so just someone that I dated and I continuously dated, and I felt sorry for her because she had 5 kids, and I wanted to continue to provide a ride for her to work, which I continually did for about 5-6 months, Your Honor.
Understood, sir. Understood, sir. Court haven't
Yes,
heard
sir.
Court haven't heard the arguments of counsel, and the court finds that the $50,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there must be a showing that either the defendant is a danger to the community or to the complaining witness, or that he or she is a flight risk. In this case, we do not have any allegations of flight. The question is whether Mr. McIntosh is a danger to the complaining witness or to the community. Court does find, based on these allegations, that a danger there is a danger. The court is going to, so therefore, the court can't issue an unaffordable bond. The court, however, based on the court is going to reduce the bond from the $50,000 cash to $50,000, 10%, with a GPS tether, a curfew of 10 p.m. until 5 a.m., and a no contact with the complaining witness. Thank you.
Thank you, Judge.
You said that, did you say 5,000, 10%?
No, I said 50,000, 10%, and GPS tether, 10 p.m. to 5 a.m. curfew, and a no contact with the complaining witness.
Okay, thank you, Your Honor.
Thank you.
Jimmy Chandler,
Yes.
calling case 220-599-4901, people of the state of Michigan versus Jimmy Lee Chandler. Defendant is charged with 1 count of domestic violence. Today's 30 cents notice. Today is the day and time for the bond redetermination hearing.
Good morning, Judge. Steve Vincent for the people.
And please, the court, bring it on behalf of Mr. Chandler, Your Honor.
State your name, sir.
Jimmy Chandler.
Argument.
Judge, Mr. Chandler is 36. He does have some prior convictions, Judge. He's on probation for a narcotic charge in Macomb County. This was a capious bond, Judge, 1,000 cash. Mr. Chandler, Judge, thought this matter was resolved. He honestly thought this matter was resolved. Obviously, it's not, Judge. He has 3 children. He works every day. He's a plumber. He needs to support his family. Now, asking the court to give him one last chance. There have been a few cases, Judge. I know the prosecutor is going to point out, but I'm asking the court respectfully to consider giving him an opportunity and giving him a personal bond, allowing him to go to work, allowing him to come and get this matter resolved once and for all, Judge.
Prosecutor.
Judge, in addition to the fact that he's on probation for their narcotics charge, he's on probation for domestic violence. He's also on probation for making a false police report. That was out of Macomb. The domestic violence was out of Clinton Township. And as a direct result of those 2 cases, there were multiple failures to appear. Actually, he should have been off probation on the making the false police report, but for the fact he failed to appear twice and had 3 probation violations. In the domestic violence case, he ended up having 4 failures to appear and multiple probation violations. And now we have this case. So quite honestly, you know, with all due respect to Mr. Reagan, he thinks that this case was resolved. He must have thought every case was resolved that he's been involved in because of all the failures to appear that he has. So he's on probation for 3 different matters right now, with capiouses and probation violations, and now he has this one too. And the ironic thing about it is, when he fails to appear, because I went through every single one of these cases, actually, if I spread this out, it would be over my entire desk right now. Every time he fails to appear, and then he gets arraigned, he fails to appear right after. He's gone through cash bonds. Actually, I think he's on a tether right now as well. So, you know what, Judge? There's been personal bonds, there's been tethers, there's been cash bonds, and now we have this particular incident. And quite honestly, I think the only reason why we only have 2 failures to appear here is because this only happened in 22. Those other 2 cases happened in 20 and 21. And that's why there are multiple failures to appear there, and that's why they're ongoing. So respectfully, Judge, everything else hasn't done it up to this point. It's a 1,000 cash surety. We're just asking you to continue.
Judge, and it is an older case, and that was going to be my point. It's not something new. It's from last year. There's been nothing, to my knowledge, between the 2. He hasn't even seen the complainant in over a year. Haven't even had contact or seen each other. So, you know, I do understand the people's position. I think a tether. I don't know if he's on a tether now, but I think a tether would be in order in this particular case. Definitely.
Okay. But Mr. Reagan, this is a, you know, I guess I'm trying to figure out, you know, how do we get your client to court though? That's, you know, I'm not even getting into the allegations or dangerousness or, I mean, like literally, how do we get him to court?
Judge, and I would ask about the tether. And Mr. Chandler, are you on a tether right now?
Yes, I am, through Macomb County.
From Macomb. So now we know where he is at all times. That's why he's locked up, Judge. So if we have a tether on him, he didn't have a tether before. If we have a tether on him, then, you know, we know where he is. And if he doesn't come to court, he's going to be in jail.
Judge, with all due respect, even in this case, there was a tether that was ordered for the defendant. There was a motion then to remove the tether. The tether was taken off.
Not taken it off.
Okay. So, I mean, and this is happening. This is just happening. And I'm just saying it like it is. I mean, I'm not trying to hyperbole or anything. There are so many failures to appear in all of these cases. There are so many violations. I mean, he's failed to show any respect to the court whatsoever.
And Mr. Reagan, you know, again, you know my position. You know, bond is not a punishment, but court haven't heard the arguments of counsel. Court finds that the $1,000 capious bond is an unaffordable bond. Court finds that that the defendant is a flight risk because he didn't come to court. I mean, I don't put your hand down. Put your hand down. I don't think he's like gonna like run and, you know, leave them. leave the state or go south or something like that. He's not that type of a flight risk. He doesn't come to court. It's just not. It's not his thing. It just doesn't work for him. And so I really don't. I don't believe he is going to come back to court. I don't. I have no faith that he's going to come back to court because he doesn't come to court. So the question is, do we rely on the tether from another municipality to get him to come to court? But I don't necessarily like relying on other people to do our business. So what I think we're going to do is we're going to do a compromise. We're going to have a cash bond in this matter, so that he'll have some invested in this, and maybe he won't forget if he has to post some money. He won't forget that he has a case because he's put some money down, and maybe trying to get that money back. So what we'll do is there'll be no more personal bonds here. And so what we'll do is we'll start low. If he posts that bond, then give him an affordable bond. And if he capious again, then we'll just escalate it. We'll do the house arrest and we'll do the 10,000 cash. And when he gets picked up or violated for something else, then we'll just keep moving it up. But the personal bonds are over now because he's a flight risk. So court is going to reduce the 1,000 capious to 500 cash. And we're going to do a GPS tether with a does he work? Do you work?
Judge, he does. He's a plumber. He does plumbing work.
Okay, so we'll give him a curfew, 10 p.m. to 6 a.m. And the no contact provision with the complaining witness continues.
Yes, sir.
All right. Please come to court. Thank you. Next person, please.
The pretrial, January 3rd, 8:30 with Judge Austin Garrett.
January 3rd, Austin Garrett. 8:30. Have a good day, sir.
I'm just gonna keep that on my desk.
Good morning, what's your name, please?
Taiwan, Corbin. Good morning.
Calling case 230-598-2001, people of the state of Michigan versus Taiwan Corbin. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Today is the day and time for the bond redetermination here.
Judge, always a privilege, Steve Benson.
We'll bring it on behalf of Mr. Corbin, Your Honor.
Argument. Mr. Corbin, state your name.
My name is Taiwan Corbin.
All right. Argument.
Judge, Mr. Corbin's 49, no felony convictions. He does have a drinking conviction, Judge. In the past, Your Honor, he doesn't have any pending cases. He's self-employed, lives in the area. Children are grown, Judge. I'm asking the court respectfully, Judge, to consider personal bond in this particular matter, Your Honor. I do understand the allegation, and they're serious allegations, Judge, always serious. But based on the fact that he has no prior assaultive history, and he's 49, Judge. This is out of character in every way. I'm asking the court to respectfully consider personal bond. Again, we're not here to punish somebody. He'll go through the process and he'll deal with the case and he'll have an opportunity to give his side in court. So I'm asking at this time, the court reduce the bond with whatever conditions the court sees fit.
Mr. Prosecutor.
Judge, this is some dark side of the force stuff going on here, and I'm not gonna make the argument that, bond is here to punish. Bond is here to protect. And in this particular instance, which I'm sure Your Honor sees, and I know defense counsel knows, the scariest part of this is, this incident appears as though it was unprovoked. I mean, we have a defendant who is in front of his house when two people are walking down the street, and he takes a baseball bat, not while they're facing him, but while their head is turned, and he bashes a guy's head with it. To the point where the head starts bleeding, and then the shirt that individual was wearing is soaked with blood. And that individual knows this defendant. He was actually with allegedly another individual, a blind individual, and he ends up IDing this defendant just based on his voice. Judge, not a punishment. This defendant clearly, just based on the allegations, based on the injuries that were sustained, he's a danger. And this was assaulted. He's been ID'd. It was in front of his home. Judge, I think it's 50,000. We would just be asking Your Honor to continue that.
Judge, we're not at trial right now. I mean, I understand that the allegations brother counsel wants to throw out, but you know, he has no prior history of doing this. There's always more to a story, Judge, than what the prosecutor tries to make it out to be in the report. It's always more to it. And in this case, it is, Judge, but it'll come out. Today isn't the day and time for that. It's bond redetermination, not trial. But he'll have his day, Judge. But in the meantime, there are other ways to assure that he does not come in contact with this man. In 49 years, he has had no assaultive history. He doesn't go around allegedly bashing people with bats in his 49 years. So I'm asking respectfully for the court to use an alternative method of tether and or house arrest. He's not, well, he is working, he does self-employment, but house arrest to ensure that the complaining witness is protected.
And Judge, I'm sorry, and I usually don't do this. This isn't just about the complaining witness. This is about the community. This was an unprovoked.
I am gonna cut you off, Mr. Prosecutor, because that's actually where I was gonna go. I'm having a hard time with a blind man and another gentleman walking down the street from a store and get beat with a bat. Just no conversation, allegedly. That does trouble me and make me want like what if I was walking down the street, or what if someone else and we just taking bats to heads? I don't, doesn't, whether, he doesn't have a history, so that Mr. Reagan is correct. That does seem a little out of character, but I'm not sure what's going on to cause this type of just senseless attack of someone. It doesn't make a lot of sense.
It didn't happen that way, Judge. I just want to let you know that has the hearsay document talking to you and getting into you. It didn't happen that way.
It's
More to it.
Yeah, I understand. Court haven't heard the arguments of counsel. Court finds that the $50,000 cash bond is not an affordable bond. In order to have an unaffordable bond, the court must have a showing by clear and convincing evidence that the defendant is either a danger or a flight risk. At this point, based on these allegations and the randomness of the crime, the court does find that Mr. Corbin is a danger to the community. I'm not even gonna make it to the complaining witness. The court is going to take into account his lack of history, and because of his lack of history, I'm not going to just continue the bond, but I'm going to lower the bond. Does your client work, Mr. Reagan?
Judge, he's self-employed. He's self-employed. What are your work hours, Mr. Corbin?
I do commercial and renovation work.
So I take it that means his schedule is flexible. It's not a set schedule. Is that correct?
Yes, sir.
Oh, okay. All right, Mr. Corbin, you're gonna have to do some virtual work. Yeah, the court's gonna reduce the bond to 50,000 personal with house arrest, and only conditions for leaving the house are medical appointments and court appearances only.
Can I say something, Your Honor?
No.
Absolutely. Your counsel is recommending that you do not, but you have an absolute right to speak. I would caution you though, is that once the person receives a personal bond on a case that was a $50,000 cash bond, and I'm already wavering because of the nature of the allegations, I don't think there's much that you're going to do to kind of convince me to give you some hours that you can be out. So but you have the absolute right to speak.
I'll go with my counsel.
Yes. Yeah, there you go. Okay, good discernment. All right, have a good day, sir.
Thank you. Y'all have a blessed day.
All right.
Yeah.
He's about to talk himself into that cash, that unaffordable bond. He was teetering. It was teetering.
Teetering.
Does that